Welcome, folks. Everyone who's joining, hello, hi. We'll give folks just a couple minutes to join. While I'm getting the chat transcript, the live caption set up, please take a sec to welcome, or introduce yourself in the chat. Let us know where you are watching from today and what kind of wellness offerings you offer. Okay, you got the captions turned on.
Oh, that's cool.
Yeah. Hey, Janet. Oh, Union Grove, Wisconsin. You know, I'm from Wisconsin, Waukesha County. So nice to have you here. Nice. Another Wisconsinite in the house. Studio owner in Ocracoke Island, North Carolina. Hello from Portland, Oregon, yoga teacher and wellness coach. Welcome. Thanks for joining us today. Hey, everyone, if you're just joining, we're just going to give folks a few minutes to enter the room. So while we're waiting, say hello in the chat. Let us know where you are joining from today and what you offer as far as wellness. Kim from Chaska, Minnesota. Kim, did you know that Offer Tree is based in Minnesota, actually? Not me personally, but our company is, so welcome. Strong Midwest representation, you did. Great. We're glad you're here wherever you're from. All right, give folks a couple minutes. Dahlia, hello from Oakland, yoga, meditation, energy teacher, massage therapist. You've got quite a few offerings. Sylvia from LA, currently live in Cincinnati, more Midwest. Yoga and somatic therapy, love it. Lisa, yoga studio owner, North Carolina. Welcome, so glad you're here. Okay. Hey, Shelby, occupational therapist, yoga teacher from Central New York State. Private yoga sessions online, great. And we've got Liz from Pennsylvania, yoga instructor and physical therapist. Wonderful. Okay, well, it's 3 after the hour, so we're going to kick it off. But please continue to introduce yourself in the chat. Let us know where you're from and what you offer as far as wellness. My name is Camille and I work for Offering Tree. If you don't know Offering Tree, we're an all-in-one platform with everything you need for your wellness business. So website, classes, courses, memberships, you can figure all that stuff out from one easy place with Offering Tree. So we want to make your lives easier as wellness business owners because it is not easy to own a business. You usually get into business because you want to support students and share what you love and share the craft that you've been working on for years. Not, go into a panic on Sunday night because of taxes or legal reasons. Definitely not speaking from experience, but we know that there's a lot of components that go into a business that your yoga teacher training or your mindfulness training or your teacher training doesn't cover. And a really big, important thing that we all have to make sure is our legal essentials, making sure our T's are crossed and our I's are dotted. So we've got you here from the software side of Offering Tree. But when we get legal questions, the people we always, our first go-to is the team at Conscious Counsel. So you may have signed up for this webinar expecting Corey from Conscious Counsel. We are so thrilled to instead welcome Chad, who's the lead attorney at Conscious Counsel. So, if you're working with Conscious Counsel in the US, you're probably working with Chad. So he's really a wealth of information and knowledge. I'm really excited to welcome him today. Just a couple housekeeping things. I will turn my camera off and I'll be on mute, but I'll still be here in the chat interacting with everyone. If you have questions as they come up, don't hesitate to put them in the chat. We'll make sure that they get addressed. And thank you so much for coming, or if you're watching the recording, thank you for watching. Okay, with that, I'm going to turn it over to Chad.
Thanks so much, Camille. I'm really happy to be here. I got this last minute. Corey couldn't make it, but Fortunately, I have a ton of experience in the legal field. I've been working in law for 10 years. I started in intellectual property, which is, if you don't know what that is, patents, trademarks, copyrights, stuff like that. And I worked in big law firms for 4 or 5 years, and then decided to work for smaller law firms because I don't like the stuffy environment, as you can probably tell from my fancy suit I'm wearing. So it's awesome to meet all of you. I'm super excited to be here. I'm going to give a little explanation of some of the essentials of the law, but please, if you have any questions, write them in the chat and I'll try to answer them if I can figure out how to use the chat correctly, which we'll see. Somebody write a comment in there now and I'll see if I can see it. How does that work? Oh, great. I don't see any comments.
Hey, Chad, I just want to let you know too, you're muted right now, but I can also collect the questions and make sure that whenever you take a pause for questions, I'll kind of be able to generate them for you. So folks.
Was I muted the whole time?
No, you just recently went on mute. So
Okay.
folks, if you have a question, answer and put it in the chat. I'll make sure I'm tracking that. And then Chad, I'll make sure to elevate that, bring that up verbally when you pause for questions.
Okay, that's awesome, Camille. Thank you so much, because it shows about one line of text of a question and then I have to click around. So anyway, so that's a little bit about Chad, a little bit about Conscious Counsel. We've been around for 5 years. We work exclusively with the wellness community. Wellness community is very broad. We work with yoga instructors, Pilates instructors, people who work in internal health, like nutritionists, people who work with energy healing, with Reiki, people who basically anything, whether it's internal, external health, physical, mental, spiritual, we work with clients like that. And we work with people in all phases of business, from super established gyms to people just starting up and people who haven't started up yet. So that's why it's great to work with Offering Tree and to partner up with them, because they're also working with people new in the industry and who really have a ton of questions. So it's really fantastic to work with them because we can handle you from the legal side. Pretty much all the questions you have starting out, which there are a ton, and they can handle pretty much everything else from the online end. So I think we really work well together. So I'd like to start today by first saying this does not count as, oh, hey, Camille. Oh, okay. This is not official legal advice. Yes, I'm a lawyer, and yes, I'm going to talk to you about the law. But it can't constitute legal advice for a couple reasons. One of which is there's no attorney-client privilege. We're in a public meeting, anyone can pop on. And so I can't give you specific, super specific advice. I can give you general knowledge. I can explain anecdotes, but I can't give you specific information to your situation. So if you would like to set up a call with me at some point, free consultation, Camille can pop in a link to set up a link on my Calendly for a free call. Camille, if you could pop that on the chat, I'd greatly appreciate it. And you can set up a call with me and I'll be able to learn more about your business and give you some free legal advice. But right now, I'd like to talk to you about some general things of starting up your business and legal concerns you may have. And I'm going to go through the most important thing. There's three documents that every business owner should have in place. Everyone, no matter what you're doing, no matter how small you are, no matter what phase of your business. The first of which is, I can't stress this enough, the most important is a waiver of liability. You've seen waiver of liabilities if you've ever gone, I don't know, skydiving or anything else, whitewater rafting or anything like that. But a lot of more businesses are having, especially gyms especially, are having waivers of liabilities in place. The reason is because let's say you own a gym, someone comes in, and one of your personal trainers drops a weight on the client's foot and breaks their foot. Next thing you know, you're getting sued for pain and suffering, for hospital bills and everything else. The sad fact is that sometimes your business doesn't need to do anything wrong. People can just bring lawsuits. And why waivers of liability are so important is because it's not just a matter of them suing you for $1,000, $2,000. They could try and take away your business. You could lose your livelihood if there's a big lawsuit that happens because someone, I don't know, passes out from hot yoga and because of an underlying condition. And next thing you know, you're being sued for $100,000, multiple $100,000 more. We've seen it happen with some of our clients. We've worked with thousands of clients in the health and wellness industry, so we've seen everything happen. So I can't stress enough having a waiver of liability in place. If you don't, get one, get one in place now. Speak to a lawyer. If it's not me, speak to another lawyer, because it's the most important thing for your business to have in place from a legal perspective. That said, there's a lot of people who have waivers of liability that they get from their friends or they pull offline because they decide, okay, well, I just want to have something in place. Beware doing that. A lot of times the documents that you're going to get from other people that you're going to get online aren't worth the paper they're written on. One thing you should know about the law is that nothing is ever going to be ironclad foolproof. It's like having a seatbelt on or airbags in your car, where you can have all the safety in the world, but someone can still, things can still happen. People who get injured will have their own lawyer, and they're going to try and get a court to throw out your waiver. If your waiver is just pulled off online, it's not specific to your business. And that super matters, because if it's not specific to your business, it's not listing the risks that they're signing away. It's not listing the possible injuries that they could have. If you have a yoga studio, the possible risks and the injuries, the things they need to be aware of, are very different than a nutritionist, very different than an energy healer. These are all different industries. And if you're pulling something offline that's basic, it's not going to be specific to your business. So can't stress that enough. That's number one. The second agreement that you want to have in place are disclaimers, terms of service, and privacy policy. I know that's three, but really it's one. If you've ever gone to a website, which I assume everyone has, and you scroll to the bottom and there'll be terms and conditions, privacy policy, usually a link, and it takes you to some page which includes a bunch of legal language that no one ever reads. But just because you haven't read it, and I'll be honest, I don't read them for every web page I go on, doesn't mean it's not important. Privacy policies are super important. That's how you're explaining what you're doing with the personal information that's provided on your website. And you can be fined if you don't have a privacy policy. In most states and most countries, privacy policies are required. And you want to be especially clear on your website or in a newsletter that you will have a privacy policy in place that explains not just how you will use their information, but how your third parties will use it, your third party affiliates. And third party affiliates could be like PayPal or any payment processor. It could be anyone that you're linking to your business. You want to have a link to their privacy policy as well. Terms of service, you generally know what that is. That's the rules of the game for your website. It's telling people how they can and can't use your website. They can't, spam other users, post illegal content, use defamatory language, really just setting out the rules of your site. So that's why every website will have that, because if someone starts abusing your site, you want to be able to have a way to kick them off. So super important. And then the most important of the three in one is the disclaimer, because the disclaimer works like the waiver of liability. Waiver of liability is for your clients, right? The people that are actually coming to your studios, they're signing the waiver of liability. Or if you have a web service, they're clicking I agree to your waiver of liability before they start your service. So this way, if they get injured or claim they get injured, you're protected. What a disclaimer on your website is for anyone that comes on your website, because you may say, let's say you practice, you give people nutrition advice and you post some general information about nutrition that that is good for generally for people to know. There could be someone with an allergy to that. There could be someone with an underlying condition. There could be someone who's not supposed to eat protein website, and then they say, well, I got sick, I got injured, now I'm going to sue the website. So what disclaimers say is they say, look, you're coming on here, we're not posting specific advice to you. It's kind of like what I said when I hopped on this chat, where I said, look, this isn't legal advice, it's not specific to you. So it's the same thing. Just like I say this, you should say on your website that there's a disclaimer that they can't sue you. And one thing to note for disclaimers or waivers, you want to make sure you have choice of law provisions. Choice of law says, I'm from New Jersey originally. I saw there's another New Jersey in here, so hello. It says, if you do sue me, you got to sue me in New Jersey under New Jersey law. And that's super important to have in any agreement, because you don't want to be drug out to Antarctica sued under penguin law. Like, you want to know what kind of law that you're in. You don't want to know the law that you're going to be sued under, and you want to be in your home state, so it's not super inconvenient to travel somewhere if you have some clients who are in another state or in another country. So that's the second thing. So the waiver is number one, super important. The privacy policy, terms of service and disclaimers, number two. And the number three is a service agreement or membership agreement, depending on your business. What is a service agreement or membership agreement? Membership agreement is a little more self-explanatory. Service agreement is what explains the rules of the game for coming to your business. What can people do and not do? What are the rules? What's your cancellation policy? What if people show up late to an appointment? Is there a grace period? Do they lose their session? What's your refund policy? Super important to have your refund policy in place when people decide to cancel their credit cards because they don't want to pay the $1,000 or whatever that's due. Definitely want to have your refund policy in there. You want to explain to your clients what they're getting for their money, so they can't go to their credit card company and say, oh, this wasn't what I signed up for. No, you did sign up for it. Here's your signature, or here's the screen where you clicked, I agree. Remember, if you have an online business, they're probably not going to be signing a document physically or even electronically. It may be a section where they need to read and click, I agree. So you want to have a separate waiver and a service agreement for them to read through and understand what they're getting for their money and the rules of the game, and that they can't sue you. These need to be separate documents, by the way, not the same document. If they're the same document, that might be a reason for the court to throw out the waiver and then you have nothing. Membership agreements are similar to service agreements. They set out the rules of the game. But the way membership agreements are different is it's a recurring membership. I'm paying, like a gym, I don't know, $200 a month. Three must-haves must be separate. Thanks. It went away real quick. Case or case. But thank you for the question. Yes, absolutely. Case. Thank you, Case. Yes, absolutely. They should be separate documents. There are some jurisdictions that have held that when a waiver of liability, the most important one, the waiver of liability is combined with a service agreement, that the waiver of liability was buried in the service agreement, doesn't count. It was too confusing. The client didn't know what they were signing and threw it out. But the 3-in-1 that I mentioned, the privacy policy, the terms of service, and the disclaimer, those can be in one link, or those can be in multiple links. Usually people just have them in one, but you'll see them 2 or 3 as well. So those ones you can combine together. The waiver, don't combine that with anything. Never. It's a bad legal practice, in my opinion. One thing about membership agreements, super important to know, in the health industry, and specifically if you're doing dance or gym or Pilates or yoga, if you have a company that's physical type of health and wellness company, your state could be very different than other states. There are some states that have required policies that say when you can terminate the contract, what language you need to have in the contract. Some states are very strict. Florida is very strict. If you live in Florida, and you run a health studio, You need to jump through all kinds of hoops and red tape. You need to register with the Department of Agriculture for some reason, because I don't know, Florida's crazy. And you need to post a bond. And the reason for all these laws is that back in the 80s and 90s, there were a bunch of predatory gym owners that would sign people up for lifetime memberships and then close their gym and then just collect money forever. And it would be real hard to get out of your contract. So as it is usually in the United States, where I'm based, the laws overcompensate. So now it can make it difficult and tricky for people who are starting up their own business, even online businesses, even people who just have minor yoga studios. For those people, it can be extraordinarily difficult legally if they don't know what they're doing. And some states have strict fines. So that's something you want to talk to an attorney about if you're thinking of having memberships, is what your state law is. So that can be a little different from a service agreement. So those are, just to repeat, those are the three most important that everyone should have: a waiver, your terms of service, privacy policy disclaimer, which goes to your website, and 3, your service agreement or your membership agreement. That's everyone, because everyone has third-party processors or a website. Everyone, it could be sued via a waiver, and everyone is going to provide either a service or a membership. But there are additional agreements that you may want as well, which could be super important depending on the type of business you're running. One of which is an operating agreement if you have a corporation or an LLC. You may know what an LLC is. It's a limited liability company. This is if you want to, start up a business and not just be under your name, because you want to limit your liability. Just a little basics on limiting your liability. This means that if your company owes debts, and then your company goes out of business, the people that are going to collect on the debt can't come after you personally. Now, again, with the law, there's always ways around stuff. So you want to make sure you're following the rules of the LLCs, that you're actually acting like an LLC and you're not just switching money between accounts, between your personal account and your LLC account. But in general, having an LLC will help protect your personal assets from debt collectors of the business. So having an LLC could be important for you. If you have a partner or independent contractors or employees or other people that are helping you, you definitely want to set up an LLC. The reason for this is, and this is, people don't know this. Well, I did before I went to law school. But if you have an LLC in place, and let's say Chad has a partner named Sally, and Chad and Sally start a yoga studio. And Sally usually teaches the yoga, but Chad comes in one day because Sally's out. And Chad doesn't know what he's doing. He screws up and injures everybody. So everyone sues Chad, and everyone says, "Oh, I got hurt, it's Chad's fault." But I'm broke, right? Now they come after Sally, and they go after Sally and they take her car and they're suing her for all their money. But wait, Sally didn't do anything wrong. Well, guess what? If you don't have an LLC in place and you have a partner and your partner messes up, or your partner gets sued by someone who says they mess up, then they can come after the other partner. What an LLC does, a limited liability company, is it prevents, if everything works correctly, it will prevent you from being sued personally if your independent contractor, or if your employee, or if your partner, or if someone else gets sued. They could sue that person and they could sue your business, but they're not going to be able to sue you individually. They're not going to be able to come after your personal assets. Again, there's rules you have to follow for having an LLC. And you want to make sure you're actually acting like an LLC. But if you're going to be working with other people, that's something you'd really want to consider, is filing for a limited liability company to protect your own assets in case you have a waiver in place and some other lawyer gets around the waiver. Now they got around the seatbelt, but you still have your airbag. That's your LLC. So that could be important depending on your business. And speaking of, if you do have people that are working for you, you'll want to identify whether they're going to be employees or independent contractors. there's a big difference between the two. Taxes is one. Are you paying their taxes, or are they paying their own taxes? Super important to know that straight up front. And two, once you have employees, if you're in the US, you're going to have different laws based on the states that you're in, and you're going to have federal law that you follow, that you have to follow. So this could include a whole bunch of laws, but will definitely include things like following OSHA, which is workplace safety, overtime laws, minimum wage laws, healthcare laws. You have to provide under the ACA, the American Cares Act, Obamacare, et cetera. You'll need to provide, if you have a certain number of employees, healthcare that meets a minimum standard. If you don't, then you have to pay a fine at the end of the year with your taxes. So if you don't want to jump through all these hoops, there are other hoops too. But if you don't want to jump through all these hoops, it's important that you have a clearly defined agreement between you and the people you work with to say, hey, they're employees or they're independent contractors. Well, specifically, you want to say they're independent contractors if you're trying to not be subject to the employee laws. Again, every state's going to be different, but generally, if you're going to have independent contractors, you can't just say this person's an independent contractor. You can't, even if they agree, doesn't matter. What matters is how is the relationship structured between you and the worker. And now this is going to be super summary, so they don't take this as gospel. But generally, it depends on the state, depends on your business, etc. Generally, the more control that you will exercise over your worker, the more likely they'll be considered an employee. What does this mean? If you're having instructors come in to teach, and because you run a general health studio and you have people come in to do meditation, and you have people come in to do yoga, and you have people that come in to do Pilates, and they can do whatever their expertise is. And you say, hey, bring your own curriculum, do what you want, just follow these kind of basic rules, like don't hurt anybody, be respectful, but it's your time, set your schedule, right? They're more likely to be classified as employees. If I have instead, let's say I have a dance studio and I have people come in to teach dance, and I say, this is the choreography, these are the rules, you're going to be evaluated based on your performance. Now they're going to be employees. Most of the time, again, depends on the state and other factors, but most of the time, the more control that you exercise over your workers, the more likely they'll be considered employees. So what can happen is, if you run a business and you don't know this, and you don't have a clearly defined agreement, right? You're saying, oh, you're an independent contractor, and then they leave, and then they are disgruntled, or even if they're the opposite, gruntled. They could say, hey, look, they're running this business illegally because they don't have independent contractors, or they have employees and they're calling them independent contractors. Now you can be fined by the state. You could get in a lot of trouble for doing that. So this is definitely something, if you're going to have people working for you, you definitely want to be able to have a strong independent contractor agreement that sets forth the rules, but also the rules of the relationship, the independent contractor to the business relationship, and makes it clear that they're actually going to be treated as independent contractors. So you're not going to be held to all this red tape that comes into play when you have employees. Now, if you have employees instead, you also want to have an employment agreement in place to explain, oh, well, is there a non-solicitation agreement? Does that mean that means they're teaching Pilates in your studio, they can't, sell their jewelry on the side or something to your clients? Non-competition agreement. That means that they can't go work in another studio at the same time they're working in yours, or even right afterwards. Which, by the way, not all states like California allow that. Do you have certain rules in place that they need to follow? There's all types of things. What can you fire them for? Usually you can fire them for anything as long as it's a non-discriminatory and non-illegal reason. But you want to have all the rules of the game, your employee handbook, the expectations for them. You really want to have everything laid out in an employee agreement so that if there's any sort of dispute, you have a strong agreement to go back to. So that was an aside based on, do you have people working for you? But a lot of people are just running it on their own. The last thing I want to talk about in terms of agreements is intellectual property. If you came in at the beginning of the chat, you may recall that I mentioned that intellectual property is how I started out in the business. I was a patent lawyer, writing patents for inventions, which is incredibly boring. It's as boring as it sounds. And then expanded to trademark and copyright. Trademark is something that every business has. When you start up your company, let's call it, I don't know, Bananas Yoga. Bananas Yoga starts up in Philadelphia, which is where I went to school. And Bananas Yoga automatically has trademark rights on Bananas Yoga, but just for that area. And only if they were the first Bananas Yoga. Don't get me wrong. If I'm the second Bananas Yoga on the same block, I'm not going to get anything. In fact, I might get sued. But if you're the first Bananas Yoga in Philadelphia, then no other yoga studio can use Bananas Yoga as their name in that area. Once you start to get brand name recognition, this you don't have to file for. This comes automatically with your business. It's called common law rights. People can't just copy your business and then you trade off the goodwill of your company and, steal that goodwill for their own by calling them, bananas too. That's not okay. Now they could have, bananas, something else that's not in the, yoga industry, like, I don't know, bananas sausages. That's a weird example, but or bananas skateboard salesman, yeah, that's fine. But generally, if it's going to be a similar type of business, you can't copy somebody else's name. But let's say you want additional rights. You want to really own Bananas Yoga for, and have the whole country within the domain of Bananas Yoga. What you do is you file for trademark protection. You register your trademark with the United States Patent and Trademark Office called the USPTO. And there's a process, you go back and forth. It takes months, sometimes over a year, but they'll look into it and they'll find out, are you really the first Bananas Yoga? Is there some other Bananas Pilates studio that's too similar? Is there another name that's similar? And they'll go through the process and you say what your trademark or your service mark is going to provide. And then one day, hopefully, if you have a good lawyer, you get that name, Bananas Yoga. No one can start up in the country. So if you start to expand to other places, you have your trademark in place and no one can hop in a year later and take Bananas Yoga in California, even though you have it in Philadelphia. So that's what trademarks are. Trademarks are, you'll see a little TM next to, I don't know, Coca-Cola or anything. That's what trademarks are. It's the mark that goes along with your business. It could be the name, or it could be, a logo of a banana practice in like downward dog or something. I don't know. But it could be a logo, or it could be a name or a stylized version of the name, which is kind of a combo with the two. So trademark is something you may want to look into if you're thinking of expanding your business, or if you just really want that name and you don't want anyone to take the name, you may want to consider registering for a trademark. By the way, different countries have different trademark laws. Corey's barred in California. I'm barred in the US. And we have associates in other countries as well that we work with when we don't know the particular law of a particular country. We work with associates overseas. But it's a good thing to know generally, every country has some sort of trademark law. And you can also get your trademark in other countries as well. You could have basically a worldwide trademark if you wanted to, if you're getting big. But that's one thing to know about intellectual property. Another one is copyright. Copyright's super important because let's say you take really cool pictures around your studio and you don't want someone else just using those pictures that you post on your website. You want to make sure you have copyright in place to prevent that from happening. One way to do that is in your agreements, you mention the copyrights. For example, in your terms of service, you say on your website, you say, hey, all this is copyrighted material. You can't go stealing my stuff and then using it on your own and passing it off like it's yours. These are my pictures I have on there. This is the language I use. This is my creative work that you can't copy. Copyrights are creative works, movies, music, pictures, like photographers. If you take the picture, you own the copyright. And copyright is a lot like trademark in the fact that once you create something that's artistic, you automatically have a copyright. If I wrote something, I don't know, a short story, I have a copyright. Boom. As soon as pen is put to paper, I have a copyright. I make up a song and then I record it. As soon as it's recorded, boom, I have a copyright. But again, like trademarks, your copyrights are going to depend upon if you registered it federally. You get additional rights. That means you can sue people for using them. You can sue them for cash for using it inappropriately, especially if they're stealing your business based on their copyright. Or you can sue them to stop them from using it. So registering your copyright, if you have copyrightable material like music or pictures or videos, etc., is something you may want to consider. And speaking of videos, probably the last agreement I'll talk about is unless I get questions on here, talk about more agreements, because I could talk about the law all day long, is a media release. What do you want a media release? Well, for one, what if you decide you wanted to take videos of your participants and post on your website, or pictures, and you take a picture of, hold on, case had a question. Let's see. Should we copyright our yoga videos? If so, do you have to pay? Oh, good question. Okay, so your yoga videos. First of all, are you taking the yoga video? Technically, unless you have a contract that says otherwise, the person taking the video is the copyright holder automatically. You can do something called a work for hire, which is you hire somebody to take the video and then the copyright belongs to your company or to you. A video shop by you, of you, yeah, that would be your copyright for sure. So again, you automatically have copyrights in that picture, meaning people aren't allowed to copy it. But if you want to enforce that in a court, then you would want to register. You'd want to register the copyright with the government. I do have another question. Question from Kim. Hi, Kim. Your question about liability waivers. How often should you have students update the waiver? Annually? That's a good question. It depends on your business. A lot of times you really only need to sign one waiver. You can have a clause that says it's a continuing agreement, which means that if they come back months later, weeks later, the same waiver is still going to apply. They don't have to keep signing every single time they come in. That said, if your business changes significantly, the type of service changes significantly, you don't want their waiver, if they first came in, to do yoga, you don't want that waiver to have to hold in place if they're now coming in to do, I don't know, psychotherapy. I have no idea. It's something completely unrelated to yoga. So you definitely, if you're changing the service that you're going to be providing, you want to update your waiver. And it's generally good practice to every 6 months to a year have them sign a new waiver. It's not absolutely necessary, but it's not bad practice. If you can keep track of it, it's not bad practice to have them re-sign the waiver, re-review it once or twice a year. That said, not everyone does that because it can be a lot to keep track of. It's not going to completely sink your case. But as with everything in the law, it's more of a gray area. The longer you go, if it's been 10 years and they signed a waiver 10 years ago and then they sue now, Could a court say, oh, they don't remember what was in it? It could happen. So I would say once or twice a year to be safe isn't a bad idea, but definitely if you're changing the types of service you provide, which brings me to a point before I get back on, to media release. You're very welcome, Kim. You want to make sure you're updating your agreements if your service materially changes. I started my own business. So I know not only about the legal perspective, but also about the small business owner perspective or starting up. And if you're a small business owner or you're starting up, especially, you know, your business could change a lot in a couple months, a lot. Like it could be completely different. You could switch from, oh, I was going to have a physical studio to go online. You could add additional instructors and different things. It can change. So it's good to be able to update your agreements if it materially changes. Are you going to be offering an additional service? It's no longer yoga, it's now Pilates. Or let's say you have a dance studio and now you're going to be adding new equipment. You put in, I don't know, ballet bar. If you're at, or you know, you have a gym and you're adding a TRX machine. You want to make sure that if you have new equipment you're adding, if you have new, especially if you have new services you're adding, that you take a look at your agreements, your service agreement, and especially your waiver, and make sure they still apply. They're still fully up to date with how your business is. Super important for the waiver, because again, if you're adding, you know, you're no longer just doing physical health, you're also giving some nutrition tips. You want to make sure that your waiver talks about the possible risks of, look, you could have an allergy, you could have an underlying condition, you know, and you want to have disclaimers in there that saying you're not a medical doctor. So, and I know I'm throwing a lot at you, but that's because there is a lot to consider from a legal perspective. People, unfortunately, you know, some people do generally get injured, generally get sick, and they feel like that someone else is to blame. Other people they make cash grabs. And what's unfortunate is in the health and wellness industry, which is why I started with Conscious Counsel, all of you are helping people. That's your job, is to help people. But unfortunately, that doesn't make you immune to bad actors who are trying to get a payday. So it's super important to protect yourself. A lot of our clients, unfortunately, that we work with came to us after it was too late. And then they say, oh yeah, now I need a waiver because I got sued for X amount. So definitely, you know, the link is in the chat. Camille, if you could post a link again to the consultation. It's a free consultation. Thanks, Camille. It's a free consultation, and I'll be able to give you more specific advice to your business instead of just throwing out a bunch of legal stuff in 40 minutes. That's kind of hard to keep track of. So yeah, I'd like to open it up to any questions anyone has. Before I do that, media release. Hold on, sorry, Camille, false start. I answered a question, I forgot about media release. This will just take a minute. If you're taking a picture or a video of your studio and there's someone in the background, you could get sued, you could be stopped from posting the video, posting the picture. You want to be able to have a media release in place so that you know you can actually post that video online and you're not going to get in trouble for it. Okay, I did get a question oh no, sorry, I tried to find the question again. It was about copyright, ASCAP, etc. ASCAP is one of 3 companies that own basically like all the music. They own the copyrights to, you know, a lot of music that you may hear. So you may get, if you're playing music, if you have a big studio, a big gym, or if you have a big presence and you're playing music, you may be contacted by ASCAP or one of the other copyright holders for music that you should pay X amount of dollars a year to be able to use their copyrighted work, their copyrighted music. Not everyone faces this. Some people do. It usually depends on the size of your company. But applying for a license usually isn't super expensive. but that can depend on, are you using it live, or using recorded video that you're sending on Zoom, or using it in your studio. One of my clients needed to sign up with ASCAP because she was releasing a series of videos online and was going to get very big, and really wanted to get that in place beforehand so that she didn't have to get contacted by ASCAP after the fact and get in trouble with them. Hold on, I have one more question, another question from Case. How do we get these documents typed up correctly so you're fully protected? Do you charge per document? Is there an online service we can use? Yeah, so I can explain a little bit how we work at Conscious Counsel. We don't charge per hour. We do charge per document, but what we do is we work with you to make sure the document actually fits your business and fits your language. I specialize especially in making sure that the language really fits what you want to say. And then you can help edit it and comment on it. And I make sure you stay on the right side of the law, so none of the wording that you change is going to come back to hurt you. And what I do is we provide, after we send you the final copy that you're happy with, we provide 6 months of additional follow-up questions, comments, edits, any help you need with the documents. We're essentially on retainer for you for the price that you already paid for the document or documents. So that's how we work. A lot of other law firms that you may work with charge by the hour, which can really add up. Also, we used to, at the old law firms I worked at, we charged by the hour, and I hated it because it really disincentivizes, it incentivizes delay, basically. So yeah, how we work is per document, and you have the document or documents finished, 6 months of service, and then we can have phone calls, set up phone calls. You don't have to worry about the time we spend on the call or the time I take to draft it. Okay, Sheila had a question. I was told that a person can still be sued even after they are no longer teaching yoga and have terminated the liability insurance. Is this correct? Still at risk? It depends on the state. That's a good question, Sheila. Thank you. It does depend on the state. There are statutes of limitations in different states. So generally, they won't be able to sue for something like that after a couple of years. But if, let's say, I was teaching yoga and someone got injured, I didn't even know about it, and I left, I terminated my liability insurance, and 9 months later, I get this lawsuit. Yes, if they got hurt when I was teaching the yoga, they could still sue me after I leave. Depending on your insurance, it should still be covered, though. If you had the liability insurance in place when the lawsuit came, when the lawsuit was incurred, when the person got injured, your liability insurance should still cover it, but that depends on the terms of your liability insurance. So that you'd have to talk with your insurer, to make sure of. That's a hard way to say that, but you want to talk to your insurance provider to make sure that if you terminate your liability insurance and someone sues you a month from now for something that happened a year ago, is your insurance still going to cover it? That's something you want to make sure of before you terminate your insurance. That's an excellent question, because that has happened to a couple of our clients. Next question from Manel. I live and work in Ontario. Does your help apply to me too? It's a different law. Corey Sterling, who owns the law firm, he's barred in Ontario and British Columbia, and he works with people from all over Canada. So yes, we can help you too. What happens with our Canadian clients, I do a lot of the work on the documents, but Corey makes sure he reviews everything. If there are differences in Canadian law, he will work on the document as well. So yes, and it is different law. And if you're in a different country, yeah, the laws are going to be different. And if you're in a different state, yeah, the laws are going to be different. So super good question. That's why I can't say, oh yeah, this is official legal advice, because it depends on your state or your country as well. You're very welcome now. Kim has a question. I teach on-site corporate yoga. Does the corporation accept liability? Or is it the yoga teacher's responsibility? Oh, excellent, excellent question, Kim. This has been coming up more and more. If I understand your situation correctly, and correct me if I'm wrong, you sign a contract with a corporation, and then you go to the corporation and teach yoga for their employees or their contractors. That can get confusing because, okay, I got it right. Thanks, Kim. Bye, Trevor. You're very welcome. It's a little bit different than your normal setup where you have your service agreements and your waiver signed by the same person. What you'll have is your service agreement will be with the corporation, right? They're the ones paying you, so they need to know the rules of if they cancel you last minute, what's your refund policy, etc. So you're going to have your service agreement with the corporation, but the waiver needs to be signed by the individuals. It's the individuals who are the participants who, if they get injured, they're the ones signing away their rights. So in my opinion, the best practice is you be there to make sure and bring your liability waiver with you. You can bring them in paper, you could bring an iPad and have them sign on that, but you want to make sure that all the participants are signing the waiver because you can't trust that the corporation's going to do it. Yes, there are situations that it was impossible. I've had clients where it was impossible to have to make sure that the individual participants sign the waiver, which can happen. And if you can't do that, if you can't be there to make sure, what you can do is you can provide the waiver to the corporation and then put in the service agreement that they're required to give everyone the waiver and have everyone sign the waiver, or that employee is not allowed to participate. You can put that in the service agreement, but here's the thing. In the end, you're relying on them. And you can put language in the service agreement that says, well, if I get sued by your employees, hey, corporation, you're going to have to pay. But good luck having them agree to that service agreement. That's the difficult part of it is, Kim, that's an excellent question, because it is your responsibility, because you're the one they're going to try and sue. The employees of that corporation, yeah, they're the ones that are going to they're the ones that are going to sue, not the corporation. So at a minimum, yes, you need to make sure everyone signs the waiver, but it helps if you're actually there, or you actually know 100% that each person is signing and you get a copy of it as well. That's a little bit trickier. You're very welcome, Kim. Case has a question. What if I'm working as an independent contractor at a studio? If you're working as an independent contractor at a studio, then if you're talking about waivers of liability, I would make sure that that the company is providing waivers to the participants. That's one, but also you'd want to make sure that you're covered under it. So having a copy of it to review the waiver to make sure that you're one of the released parties. That means, the parties that they're not allowed to sue. That would be, super important to make sure, yeah, their waiver is enough. It depends. Yeah, good question. It depends. Are you covered in your waiver? You could have a waiver that says, I'm not going to, I don't know, I'm going to use Bananas Yoga again because I like they could have their waiver say, Bananas Yoga, you can't sue us, but they don't say anything about their contractors. Yeah, well, then you're not covered. So you want to make sure that independent contractors are covered in the waiver, or else, yeah, they can't sue Bananas Yoga, but they could still sue you. So that's something you would like to, at least review on your own to make sure independent contractors are covered. But even better, go over with a lawyer to make sure that you are covered under their waiver. Oh, you were very welcome, Case. I'm glad I can help. Yeah, it's I love doing these things because I know before I went to law school, I knew absolutely nothing about the law. So, so I can only imagine other small business owners, or I can imagine because I was there. I didn't know the difference between a copyright and a trademark, let alone how LLCs worked or waivers of liability or anything else. So I'm glad I get to give back to a community that really helps their clients every day become healthier, because that's it's super important that companies like yours are protected, because you're really helping the community at large. And if there's any other questions, we have about 5 minutes left.
Yeah, I was just about to say, last call for questions. Thank you so much, Chad, for all of this awesome advice. All right, we got another one. Would you like me to read it out loud, or you got it?
Oh, I got it. I figured it out now, and I won't accidentally mute myself again. Nita or Nieta, I'm not quite sure, asks, how does liability work when you're in a public place, like teaching a class at a fair, for example? Oh, I had this question recently, actually. This can be more difficult. You do want to make sure that if you can, people sign the waiver. If you can't, because it's a public place and people come in or out, that can be tricky to do. I would suggest handing out a waiver or having people sign a waiver if you can. If you can't, I would say to have a disclaimer at the beginning, and be able to speak some language that says, look, you're doing this at your own risk. But that's more difficult when you're performing at a fair. The good thing, Yeda, is that people usually don't sue in that situation. If they're coming into your place of business, or if they're specifically signing up for your services and they're paying a price, or they're paying to watch your YouTube videos or your Zoom lessons, they're more likely to sue. If someone's walking in a public place, much less likely you're going to get sued. Waiver of liability is preferable, but I've worked with clients where that just wasn't possible. And the best they could do is say a disclaimer at the beginning and saying that, that you're not responsible if they get injured and they're performing at their own risk. Unfortunately, that's the best you can do if you can't have someone sign a waiver. Anel asked, I'm a sole proprietor so far. Do you recommend to incorporate? Depends on your business. Having an LLC is good for anyone in terms of liability of debt, meaning if you rack up debt from your company, being able to protect your personal assets from that debt. But especially important if you're going to be working with a partner or contractors, or you think that might happen in the future, then I would definitely 100% suggest it. But the timing of it depends. I mean, it can, if you're willing to spend the money up front to do it, it's not super expensive. But if you're willing to do it up front, yeah, it's certainly good. Yeah, if it's just you for now and you're starting up, yes, I would still recommend it. It's not the highest priority item in the world for you, because it's just you, and you're probably not going to rack up a bunch of debt in the beginning, but it should be on your radar. And starting now, it doesn't hurt to do it. Not at all, because at least you'll have it in place, and that's something you won't have to worry about down the road. If you do decide to bring on a partner and an independent contractor, and then you forget, oh no, I never put an LLC in place. So still a good idea, but definitely if you're going to have someone working with you or for you, or if you're big, or if you start taking on loans. Thanks, Sandra. I'm glad I could, or Sandra, also not sure. I'm glad I could explain the stuff. I know there's a lot to throw at you. Thanks everyone for listening, because I know sometimes when you talk about law too much, it can be a little much to take at once. But again, if anyone would like to talk to me more and have more specific advice for your business, please send me LLC, Yoga for Health by Parna, LLC, Limited Liability Company, which says exactly what it is. It's a company where your liability is limited, both in terms of debts and in terms of injury. You're very welcome. But yeah, please, if you have more questions for me, or if you have, you would like more specific, oh, thanks, Camille. Yeah, please sign up to have a free consultation with me. Also, Camille, if you could post a free legal checklist. We also have a legal checklist for you, which because I know I threw a lot at you verbally. We have a checklist that's, you can click on the link and you kind of get like a basic checklist as well that has it written out, some of what I've said.
We'll also share all these links in the replay email, which you'll get within 24 hours. So if you're watching this on the replay or you didn't get a chance to grab those links here live, don't worry, we'll make sure you've got them. Okay, well, thank you so much, Chad. Thank you so much for everyone who joined us today on this Monday. I hope the rest of your week is smooth sailing with no legal troubles, and we'll see you for the next webinar. Thank you so much.
Thanks, everybody. Thanks, Camille. It's great to be here.